Okay, now we're going to look at medical record entries. So those entries made within basically any health record. The first thing we look at as far as documentation is the quality. And the quality of the medical record as a whole depends on those providers that are actually making the entries into the record. And there will be multiple providers. Depending on the setting, there will be multiple providers that actually document in the patient record. Now, all of those individuals or providers that document in the record need to understand the importance of creating legible. Legible means being able to read the information. Complete, accurate, and also timely entries, and also the implications of not doing these things or failing to do these things. A lot of this is covered during a hospital orientation. When a new employee starts, then much of this should be covered at that point in regard to the proper documentation in the health record. Now, in addition to protecting the provider in a negligence action, so if a patient brings a lawsuit for malpractice, in addition to protecting whether it's the facility or the actual healthcare provider, that record can also provide evidence of the actual care given to the patient and will help defend against those charges of fraud and abuse in billing. And we're going to talk about both of these. So we think of it as a legal document, the health record, that can help defend against any type of malpractice action or negligence action, but also with the fraud and abuse laws in regard to billing, that health record can show exactly what was done and match that up with the bills. And so if it's not written in the health record or documented, it was not done. So if something's billed and then that service is not documented as being provided, then that could be considered fraud and or abuse. Also, if a facility fails to comply with medical record accreditation standards through Joint Commission or any other accrediting agency, the conditions of participation, or state and federal laws, it will risk losing its license. It could lose its accreditation and or its Medicare certification, or all of the above. And so that's why it's so important. Anytime, for example, the Joint Commission or Medicare or state, or could be the federal agencies, come in and do surveys to continue, for example, with accreditation or to be accredited initially, much of the time is spent reviewing medical records, because that's where all of the proof of care, whether it's quality or not quality, and all the majority of the standards. Now, there are standards with Joint Commission regarding the physical aspect of the setting, administrative things, but as far as care given, they'll go back and look at medical records. I say go back. They used to pull old medical records, say I need to see this many patients who had this done. I need to see this many patients who were either secluded or restrained. I need to see this many records. And they were looking for certain things to make sure that the standards were being met. Now, they'll go up on the units. Most hospitals, the nursing units or the floors, there's multiple floors, and so they'll go up and look at active charts. And again, when we're changing to this electronic format, they can have easy access to both old and new records. But that's where the proof is as far as the care that's given to patients, and also proof of meeting a lot of the standards. Now let's look at legibility and completeness of the entries. And this is kind of like a broken record, I understand, but the medical record is usually the most important document available to the healthcare providers to defend in a case or a malpractice action if it's brought. Now, medical records are ordinarily admissible as evidence of what actually occurred in regard to the care of the patient. And we're going to define some of these things. Admissible means it's able to be used in court as evidence. Now, if that record's not legible or it's incomplete, the provider may not be able to successfully defend against the allegations of improper care. Maybe proper care was given, but it's not documented in the health care record or the health record, and so there is no proof. And so if it is, and it is able to be admitted as evidence, that can be proof that actual quality care was given and that the facility or the provider was not actually negligent. Now, the book points out that some courts will allow the jury to resolve any ambiguities in a patient's record in favor of the patient. We say ambiguities. If we're saying a record is accurate, but maybe it says one thing in one part of the record and contradicts itself, another provider writes something and it contradicts what another entry was, that sometimes the court will just give the jury instructions to say, you can decide in favor of the patient because of these ambiguities in the record. And that's all that ambiguity means. If there's a conflict, there's a difference, and one part says one thing, one part of the record says another. Another thing about medical record entries is they need to be clearly written where they can be understood. They need to be concise and to the point. In other words, not a novel, the facts, only the facts. And also in a language that can be understood by all healthcare professionals that treat the patient. That's the big thing about medical terminology, is so that everybody knows what's documented in that record or understands what's documented in the record. And a lot of times, an ambiguous or an illegible record is worse than having absolutely no record at all, because it's going to look sloppy. It's going to give the idea that, well, your records are so bad, why are we supposed to believe that the health care you provide is of any quality? Now, if a hospital or a healthcare provider can demonstrate by testimony that in accordance to its policies and procedures, that it regularly keeps complete and accurate records, the absence of certain notations may be used to defend against a claim of negligence. Meaning, if it's the policy of the facility to document certain things in the record, and those things are there, and they do it on a regular basis, if they can prove that, then if there are some notations that are absent because they're not, let's just say, pertinent, and that's how it's normally done, then that can be used to defend against a claim of negligence. And so that's really important that we have policies and procedures on how to document and who can document in the record, and that they are followed. Your textbook points out that some courts allow juries to infer negligence by healthcare providers based on reasonable conclusions drawn from an incomplete patient record, while other courts have gone further and have instructed juries to presume there is negligence when there are omissions in the medical record. And so what are the difference in these two terms? Sometimes the court has told the juries, well, you can assume that there was negligence. You can make your own decision based on the conclusions you draw from this incomplete record. Or presume, meaning I want you to assume that there was negligence because there were omissions in the medical record. So again, the court can give instructions to the jury as far as inferring or presuming certain things because the information is not in the record. Also, if there are omissions or things are left out of the record, the provider may not be able to be reimbursed for actual treatment or test or things that are done to the patient. They could have actually been done, but again, if it's not documented in the record, you can't go back and prove that certain things were done, and so they won't get paid for it. So that's another important aspect in regard to keeping complete medical records and accurate medical records. And remember, and we say this over and over again, in regard to documentation and patient care, if it's not written, it didn't happen. Doesn't matter what you say. Well, we did do this. Well, you didn't write it. You didn't document it. Now, HIPAA created a new offense of healthcare fraud, which is defined as knowingly and willfully executing or attempting to execute a scheme or artifice to defraud any healthcare benefit program or to obtain by means of false or fraudulent pretenses, representations, or promises any of the money owed by or under the custody or control of any healthcare benefit program. And no, I will not ask you to regurgitate that on a test, but HIPAA actually created the healthcare fraud offense, saying that you can't willfully and knowingly bill for services, and it could be through inaccurate coding, intentionally, to get more money, and that's considered fraud. Of course, there's the abuse part, and that's when it wasn't necessarily knowingly and willfully. It was just where it wasn't done correctly, and nobody did it intentionally, but the codes were assigned in the wrong way. Therefore, the hospital or the provider got paid more money than it was supposed to get, than the hospital was supposed to get, and that's known as abuse. But the fraud part is you knowingly and willfully execute or attempt to execute fraud from getting benefits. So again, if that record is accurate and complete, it'll be the provider will be able to prove whether services that were billed for were actually given to the patient. Now, written laws, regulations, standards from accrediting agencies, and also those recommendations from professional associations impose standards in regard to the legibility, accuracy, and completeness of medical records. Now, there have always been issues, especially with paper records, in regard to legibility of handwriting. And I know that when Joint Commission would come for a survey, and if they were looking, when I say they, I mean the commissioners, the surveyors, were reviewing medical records, and they came to a chart and they couldn't read the physician's handwriting, then they'd just throw it aside and you would get written up for that. It had to be legible, and sometimes that was a challenge, trying to read all different individuals' handwriting. So the legibility, the accuracy, and completeness of records are all addressed in laws on the state and federal level, on regulations from administrative agencies, Joint Commission standards, or other accrediting standards, and also recommendations of professional associations. Here's an example, the conditions of participation. So one of the standards or the conditions says all entries to hospital records must be legible and complete. And that says a lot in that one sentence. We have to be able to read it, and it cannot be incomplete. It has to be complete. Now, Joint Commission standards, they state things a little differently, but the Joint Commission standard says that data be collected in a timely, economic, and efficient manner using the degree of accuracy and completeness necessary for the data's required use. And that's saying it. It's really saying the same thing, just in a different way. And when you see data, a lot of times you think of electronic health records or collecting data, but any data that we collect, whether it's in paper or electronic form, or any of that information on the patient, that data, it still falls up under the same standard. Now, timeliness. And we've talked about time limits, where Joint Commission or Medicare says you have to have H&P on a chart within 24 hours of admission. The chart has to be completed within such and such a time, 30 days. But in addition to the accuracy and the legibility of the records, it's very important for records to be completed in a timely manner. You know, the standards are there. There's not the standard police standing there 24/7 going, oh, but this record's 31 days old, so we're just going to close the whole place down. We look at percentages of how many times we got it right, and we did have records completed in time versus when we didn't, because sometimes they're not completed on time. But it's important, not just because it's a standard, but the policies and the bylaws at the hospital or the healthcare facility should require the staff members to complete patient records within a specified time. So there should be a policy on the book, not just a Joint Commission standard or a Medicare standard or condition of participation. We have to go a step further, and we have to develop a policy that says that this is the time period for completion of records. And also that there should be an automatic suspension of clinical privileges for those who fail to comply with the time limits. I think we discussed this back in 151, where we're talking about record completion. In incomplete records, you analyze records and find out what's not on there, and then the physicians come in and complete their records, and they have a certain amount of time. Well, in the real world, there are some physicians, they're obsessive about it, and their records are going to be complete and perfect and everything. And there's others that you have to beg and plead, and they're just it's just not in their personality to get these records completed on time. And that's one of our jobs, to make sure that the records are completed on time. And so one of the tools that we have is to have automatic suspension of clinical privileges, meaning that if a physician has records that are, let's say, 25 days old and the limit is 30 days, then they'll be sent a letter saying these records are incomplete. If they are not completed by midnight on such and such a date, then your privileges at this hospital will be suspended until the time that these records are complete. It's not a permanent thing, and it's not something that goes on a physician's record as far as being kicked off the medical staff somewhere, but they can't. A lot of times the hospital will allow for suspension of admitting privileges. So if a physician can't admit patients, then they're not going to be able to treat patients. Another hospital may do it a different way and say they're going to suspend the privileges of using lab and x-ray services. Well, a physician cannot treat patients in a hospital if they can't order particular tests to be done. So there are different ways to do it, but that's usually a function in health information, is to monitor these charts and these delinquent charts, and then send out those letters and let the physicians know, okay, you have this many charts that are delinquent, and tell them the exact charts and the dates by which they need, or by which they need to be completed. And when we do this, and we're given this right to do this, we better make sure that we know what we're talking about, and that if we say that this record's incomplete because it lacks a discharge summary, we better be sure that that discharge summary was not actually done and just hadn't been put on the chart. So we have to be very, very careful of this. And this, like I said, is usually a function of the Health Information Department. And of course, as we go with the electronic records, the system itself will notify the physician of any delinquencies or incomplete parts of a medical record. Now, late entries are made to medical records. It happens all the time. Late entries mean that records are incomplete for a period of time. and the entries are made after the care or the incident actually occurred. Now, the later the entry, the worse it's going to look if there ever is a lawsuit. And I keep talking about malpractice or professional negligence actions. They're not common. It's not something that goes on all the time. But we've always been of the mindset that we have to treat every record as if there will be a lawsuit from it. We don't want to go back later and go, well, this record was sloppy and the things weren't done on time and it wasn't corrected properly and there's holes in this record. We want to assume that every one of those records is going to go to court, even though that's not the case. A very, very small percentage of them actually are used in court cases. But late entries that get later and later and delinquent entries, they just look bad if a case actually goes, if there actually is a malpractice case. Entries that aren't made at the time of service are less likely to be accurate and have less credibility than those made immediately after treatment was rendered. And if you think about that, as humans, our memories fade as time goes by. And I'm not talking about the older you get. I'm talking about if something happened, it's going to be fresh on your mind right after it happened or while it's happening versus a week later when you're trying to recall the facts. And so those entries that are made right when treatment are given are those that are more credible. Now, if we make entries, or somebody makes entries, it would not be us, but if the providers make entries after there's already a lawsuit threatened or that lawsuit has been filed, it's really going to look bad because it may appear that it's been self-serving, that I'm going to go in here and I'm going to change things in this record or add things to look good. And so that's really something that we monitor, and most of the time in most of the places that I've worked is that if there is a lawsuit or we've gotten a subpoena for a record, that record is taken from the permanent files and locked down so that no one has access to it unless it's for patient care. I remember at one hospital where I was the director of health information, in my office there was a file cabinet specifically for this, and it was locked up. These records were locked up. I had a key, and also the nursing supervisor had a key in case a record was needed after hours only for continuing care. If the patient showed up in the emergency room and they needed the old record. But other than that, it was just under lock and key, and nobody had regular access to the record. Now let's look at authorship and countersignatures. Now, as a variety of healthcare providers document in the patient record, it's important that we have policies, and that's a common theme. You keep hearing me say this. We have to have written policies on who can do what and how to do it. The how to do it would be the procedures. But it's important to have policies that address who can make entries in order to safeguard the quality of patient care and reduce liability. We need to have policies to say who is allowed to document in the record. And I don't mean by name, that Jane Doe can document in this record and John Smith can document. It's usually by position that nurses can document in particular parts of the record, physicians, physical therapists, and it needs to be spelled out. We as health information professionals have lots of contact with the record, but we do not document in a patient's record. We use the documentation that's there or tell other people what they're supposed to document in the record, but we ourselves do not. And so we need to have policies. Joint Commission, The state, the federal government, they don't have laws saying only these people can document, but they will have standards or laws saying there need to be policies that define who can document in a patient record. And as I just said, state law usually doesn't mandate this, but it should be specified in individual hospital policies. Now, some entries require a physician's countersignature, and the purpose is to require a professional to review and indicate approval of action taken by another practitioner. For example, an intern writes in the patient's record, and the attending physician is required to come back and countersign under the signature of the individual who actually made the entry. It's showing supervision, that this individual is being supervised. In most states, it's a violation to practice medicine without a license. Most everybody's heard that. And so that's why it's so important that that entries in the record would be countersigned, because if not, it's as if someone who is not licensed to practice medicine, who is in training, is actually in there treating patients with no supervision. And so that's the purpose of the countersignatures. So countersignatures of entries in the record prove that the unlicensed practitioner is actually being supervised by a licensed practitioner. Same goes for nursing documentation. If there's nursing students that are documenting in a health record, and this happens at teaching facilities, teaching hospitals, then an actual nurse, a licensed nurse, a nurse with a license, where there's an RN, usually an RN, will come back and countersign to show supervision. Now, with the authentication of records, traditionally it was just a signature, handwritten signature. And we've talked about this before. Another way to authenticate records, this would be on paper records, would be a rubber stamp, or if it's electronic, it would be a computer key using a PIN number or actually a digital signature. And if a rubber stamp is used, the Joint Commission requires a statement be placed on file in the administrative offices, not in health information, in the Office of Administration of the hospital, stating that the individual whose signature is on the stamp is the only one that will who will use that stamp. And I know just through experience, if where I worked in one facility, they did allow rubber stamps, and those statements were on file in administration, and that was one of the first things Joint Commission asked to look for. Do you allow rubber stamps? Yes. I need to see, or we need to see, all of the statements that are on file in regard to those rubber stamps, and those statements will have usually a copy of that stamp and then the real signature of the physician stating that this is my signature, this is my rubber stamp, and I am the only one who will use this rubber stamp. And that makes sure that that stamp isn't just handed off and said, here, go sign all my records. Just use my stamp. That is not okay. And also there are specific Joint Commission standards that will require the minimum that has to be authenticated, meaning the things that have to be signed in a record. H&Ps, op report, consultation, and discharge summaries have to be signed at a minimum. And then Medicare says that all entries in the patient record be authenticated and dated promptly by the person that documented them, that they couldn't be signed by someone else. Now let's look at, it's really a concept, it's a process known as auto-authentication. You may hear this It's a process by which a physician authenticates a report by computer code before it's ever transcribed. So in other words, the physician will enter an electronic signature or a pen and agree to review and correct the transcribed report within a certain time frame. And then if there are no corrections to be made, then the record is then deemed complete and that electronic signature is permanent. This is not okay according to Joint Commission and Medicare. So a physician sits down and dictates a discharge summary, automatically puts in their PIN number or their automatic signature and says, okay, if I don't change this within a week, this means that I agree to all this information that I have dictated. It hadn't even been transcribed yet, but just say within 5 days of transcription, if I don't change anything, then I agree with everything. Well, you can see where that would not be acceptable, even though it may go on. Joint Commission and Medicare have said they do not accept this method of authentication. That you can't, it's like signing a blank check, basically. Here, I'll just sign it, you fill in the rest. And I don't see the completed check ever. I'm going to sign it on the front end rather than the back end. And so that's what auto authentication is. And again, know that neither Joint Commission nor Medicare will accept this. In regard to verbal orders, we talked about verbal orders and telephone orders, those types of things in 151. So this is a common practice to get that the physician gives orders verbally, and then whoever is deemed to be responsible for taking those orders and transcribing them or writing them out for the physician will do so in the record. Now, some healthcare facilities will not accept verbal orders unless that situation occurs where verbal orders are unavoidable, meaning an order is a physician's called from home, at home or from the office and say we need this on this patient, and the physician will give a verbal order or a telephone order because that they're not in the proximity of the record and can't actually either key into the electronic health record or write in a paper record the order. In some places, the physician will be standing right there at the nursing unit and give a verbal order rather than writing it, and then it will be written by the nurse, and then the doctor comes back and signs the verbal order. But the written orders are always preferable to verbal orders because any time that there is a verbal order, there's a bigger chance for an error to occur because it's in two people's hands. The doctor's saying it, the nurse is writing it down, rather than the doctor just writing the order him or herself. Now, we also have to have policies on the books that for those individuals who are authorized to receive an order from a physician, a verbal order, and to transcribe. And transcribe doesn't necessarily mean to be typing it out. It means just writing out what the physician ordered or what the physician said. So we have to have policies on the books to say maybe only registered nurses can receive and transcribe verbal orders from physicians on the medical staff. And again, it's not by name, it's usually by position of who can take a verbal order. Now, errors happen because the people that are creating these entries in health records are people, and people make mistakes. And sometimes those mistakes have to be corrected, and the record has to be altered, and so there will be errors. But generally there are two types of errors that are made, and there can be minor transcription or spelling errors. For example, a patient's name on a discharge summary or something like that was not spelled correctly. If it was Smith, S-M-I-T-H. Maybe it was supposed to be S-M-Y-T-H-E or something. That's Smythe, really, but just something, or the patient's first name was not spelled correctly. That's a minor error, as far as a transcription or a spelling error. But then there's more significant errors involving test results or orders or omissions or misinformation that has been put into the record. And I'll say normally, rule of thumb, and I'll say it's most everywhere I've ever worked, that if you corrected, for example, you had a discharge summary and the medical record number was typed or transcribed onto that discharge summary, and it was wrong medical record number, maybe the transcription is transposed a number, you just draw a line through it and put the right medical record number. That's nothing in regard to the patient's clinical information. That was a transcription error or something like that. So we could do that, just make that correction. But as a general rule, the person who made an error in the record should be the person to correct the error. An example, a nurse should not correct physician documentation. The physician should correct the documentation. And there are different methods for making corrections. Just cross out the incorrect entry with a single line, enter the correct information. It needs to be signed or initialed, and usually I didn't put it up here, but dated, and then the reason for the correction. For example, it was written on the wrong record, wrong patient chart, and that happens. You'll see that somebody picks up the wrong record and starts to write in the progress notes and then realizes, oh no, I have the wrong patient's chart, and then so it's not a big deal, but the main thing, the original entry should never be erased or obliterated in any way. No whiteout, no liquid paper, don't color over it where it can't be seen, because this is going to look suspicious. And again, if that record ever went to court and there is information that's erased or obliterated, it's going to look bad. And so to make a correction, I just gave you an example here of the correct way to make a correction in the health record. This originally said, it is on a progress note from a physician. It said the patient is tolerating diet well, no complaints are voiced at present, and realized Dr. Jane Brown wrote that and then realized that she had the wrong record, so wrote under it, put a single line through it, wrote under it, error, wrong patient's chart, and then signed that correction, signed and dated it. So anybody can see what it said originally, but also the reason why. And sometimes that it's as simple as that, wrong patient's chart. Or maybe as someone's documenting, they write something in incorrectly and it's on the right patient's chart, it's just the wrong information. They realize it, or he or she realizes it, draws a line through it, writes the correct information, and then signs and dates that or initials that correction. And so that's how it should be done. Now, if we're dealing with electronic health records, the system's going to keep up with any type of alteration or change that's made to that record. The original information would never go away, or that original data, but the corrections can be put in there. Now, anytime there's an amendment made to the patient's record by the patient's request, it should be done as an addendum to the record that is permanently filed in the record. So, for example, HIPAA gives this right, but even before that, if a patient looked at his or her record and thought that there was something wrong, that there were some facts in there that were not correct, then we could put, if it was determined that that was what the case was, instead of, for example, on a discharge summary it said something and the patient thought that that was the wrong information, instead of, okay, we'll just tear up the discharge summary, no, that remains, and then an addendum is put on the record making that change, but the original is on there, but the addendum is permanently filed in the record. And if we released any information, we would send the addendum with the original information. So again, we just don't ever tear up anything that's wrong. The only exception would be somebody sits with a new set, a blank page of progress notes, and they're going to write on this new blank page, and the first thing they put down there, or their entry, they mess it up. They could tear that up and get a new clean sheet out and start over. They're not changing any information. It's just that they messed it up. But if other entries had been put in after that, they would never go and destroy that page of progress notes. They would write with the next available space and make any corrections that needed to be made. So that's information on who can make entries in the record, how they should make the entries, and also how to amend or change entries in the medical record.